Handshake deals in Ireland, Irish property law. Are handshake deals binding? In Irish property law, handshake deals, that is, informal verbal agreements sealed by a handshake, are generally not legally binding when it comes to the sale or transfer of land or an interest in land. The reason for that is it goes back to the Statute of Frauds Act of 1695. This was an act for the prevention of frauds and perjuries, and it obliged a note in writing of the deal. I forgot to mention there, the memorandum or note in writing pursuant to originally the Statute of Fraud 1695 must contain the following details: the 4 Ps, the parties, the price, the property, and the particulars. And the particulars is the statement of the material terms of the contract. So the note or memorandum must contain the 4 Ps: parties, price, property, and particulars. So the legal requirement in 2025 is set out in Section 51 of the Land and Conveyancing Law Reform Act of 2009. This section codifies the long-standing rule originating from the Statute of Frauds of 1695 that, quote, "A contract for the sale or other disposition of land shall not be enforceable unless it is in writing and signed by the parties or their authorised agents." So, verbal agreements, even if accompanied by a handshake, do not satisfy this requirement. If there's no written contract, then there is no enforceable deal in relation to land in most cases. That's the general position. There are very limited exceptions, and they are to do with the equitable principle of part performance. So the limited exceptions under the doctrine of part performance are narrowly interpreted by Irish courts. And to rely on part performance, one must show 1, clear evidence of a contract, including the essential terms. 2, that the party seeking enforcement has taken significant steps in reliance on the agreement. 3, that it would be unjust not to enforce the agreement. An example of this would be, for example, if someone moved into a property, made improvements, spent money, paid substantial money based solely on a handshake deal, and then there's evidence of this, well, a court might enforce it. However, courts are cautious and rarely invoke this exception unless the facts are very compelling. The practical implications of this situation to do with the sale or purchase of land are: 1, always get property agreements in writing. 2, handshake agreements may be morally compelling or culturally significant, but they won't stand up in court without documentation. And 3, for leases under 1 year, oral agreements may sometimes be enforceable, but even then they come with risks. Hope you find the video useful. If you do, it's only a short one, but it does look at the question of handshake deals and the difficulty that Mr. Magner has in his case there in trying to enforce the deal, the handshake deal that he had or he claimed to have with Thompson Moores in relation to the Barn estate. If you liked the video, hit the thumbs up button down below. Thanks a lot.